Hi, everybody. Happy Friday. Nice to see you. Hope everyone is doing well. Uh,
Hello.
right. We're going to do the EAGLES, right? Eagles. I love that jacket. Look at Madeline out there. Go, Madeline. High five. Yeah. So hopefully you're all Eagles fans. And even if you're Giants fans, we have the Giants #1 player now. So you still got to root for the Eagles. Um, so the Chiefs, I like the Chiefs too, just not when they're playing the Eagles. So hopefully it works out for the Eagles. Um, what do we have today? So let's start out with our little stupid lawyer announcements that we always have to do, right? So this is general information only, educational purposes. They do not constitute attorney-client privilege communications. The information is not legal advice. To obtain legal advice, you got to go hire a lawyer and sign a fee agreement. And no information will be kept confidential, but I do really appreciate you coming. So we cleaned up our website a little bit. So I'm going to share the screen just so. Are there any are there any updates on FinCEN? Alan, you jumped the gun. So you jumped the gun. So now you get put back to the starting line. But thanks for the note, Alan. Gosh, I didn't even catch my breath, Alan. So no, we're not going to talk about FinCEN yet, but I will get back to it. So what I'm going to show you though is we cleaned up the website a little bit, and I'm going to share screen. So there's Google. Right. Let's see. Share. Right. Share
Yep.
screen. So there's Google, right? Share screen. So if you just go to Google and type in Fran McGovern, you're going to get the associationlawyers.com. I don't know if you can see that. This guy on the right there is not me. He's not me, even though he's also Francis J. McGovern and he's a lawyer. Sometimes he gets his mail, gets my mail, I get his mail, we get the same mail, but that's not me. This is me, this guy over here, even though this picture needs to be updated. I have gray hair now, and that was still brown hair. But I want to show you this. So we scroll up. It gives you the associationlawyers.com. We go to the homepage, right? Hopefully this works. Homepage, nice homepage, towers, everything like that, fun stuff. But we go Friday with Fran in the gold button in the upper right-hand corner, because a lot of people say, "Hey, Fran, I want to get the First Friday with Fran recordings." Just click on First Friday with Fran. Hopefully it works because there's a little funk. There we go. So First Friday with Fran, right? Then they all come up. So you can push play on here. You can go down and reload more. There's a button there for reloading more to go to older ones. But if we push play, this is the big secret, and those of you who do podcasts know this all the time. So you push play, really annoyingly loud. Sorry about that. But if you go to this button here and go to settings, and you just want to blast through stuff, you go playback speed, hit playback speed, and go to 1.5 times playback speed, even up to 2 times playback speed. So you can adjust the playback. So you don't have to listen to me drone on and say and ah and all that other annoying stuff, right? You can just blast through it if you want to get to the point. All right, so that's the website that has the past videos on it, and that should be helpful. So anyway, that's just a way that if you want to look at the videos, you can look at them and you can play them back at usually 1.5 times speed to really cruise through them pretty quickly if you want to try and get the point of the day. So the dog of the day today, Carrie Miller, is she with us? Carrie Miller from Taylor. Hey, Carrie. There's the dog of the day. That's from Carrie Miller LaMonica with over at Taylor Management. And this is Geo the dog. And he is, no offense, Carrie, he is a mutt. But he is living a nice life with Carrie Miller LaMonica now. So thanks so much, Carrie. Good to see you. And thanks, Gio. And now we'll jump right in. So what are we talking about? Remember the Alamo. So myself and Kevin Del Rossini and Weston Denon, who are other attorneys here, we went out to San Antonio last week and spent 4 days in San Antonio at the CAI National Law Seminar. And at the same time, they have the CAI National Law Seminar, they have the CAI National Insurance Seminar. So they're at the same hotel, at the same place. So generally speaking, I jump into the insurance seminars because they cover a lot of legal topics that play into the insurance side of what we all do and what we all have to deal with. And insurance, right, is usually the #1 and or #2 expense in your budgets, oftentimes #1, right up there with landscaping. So it's really annoying and really expensive. And you might imagine that the speakers at the insurance seminar, national insurance seminar, said, what? Insurance premiums are not going down, right? Insurance premiums are not going down. And in fact, they had to make great efforts not to talk about California and Florida the whole time, right? In between wildfires and losses based on the storms that have hit Florida, they really have a hard time not just focusing the whole world on Florida and California. But they did that, and I thought we should talk about some issues with insurance and talk about this as a point one, then get further in depth next time we talk, because it's going to be a bigger issue in all of our lives as insurance gets more and more expensive. So that we had the Community Association Law Seminar, I should say what that is. The Community Association Law Seminar is where association attorneys from all over the country come in and attend seminars for 3 days just on community association law. And like I said, there's the insurance piece that goes along with that. So we talk about current cases, current trends in the law, what's happening in the law, what we anticipate in terms of legislation, and basically just a general idea of what's going on. The Community Association Insurance Risk Management Specialists, they use the initial CIRMs. So for any of you who work, and you should be working with specialists in the association insurance industry, these professionals in insurance are the ones you should be sitting down with, in my opinion. Some people don't agree with me, once a year, and talking through your coverages, talking through your limits, talking through your deductibles, talking about your loss runs, talking about risk management. How are we doing? How can we put our arms around this? Even if we can't limit our insurance today, how can we manage our risk going forward that at least we don't have a crazy loss run going forward and we don't continually get jacked, right? So insurance is important, but it's not the only risk management tool. So insurance is a way of spreading risk, right? You buy insurance, people think, oh, it's just an insurance company. How do insurance companies work? They sell policies to whole thousands and millions of people and millions of associations, right? And spread the risk across all those associations in the hopes that if you, God forbid, one of your buildings gets burned down or something bad happens in your community from a liability standpoint, you will be able to draw on the resources from the insurance company to pay for that, we'll say, rare loss, right? So you're drawing on the funds being paid by thousands, hundreds of thousands, millions of other policyholders to pay your loss. And that's why when you have wildfires that burn down a good chunk of California, or floods and hurricanes that hit Florida, you wind up taking the hit in part on your premiums as the insurance companies try to adjust for those massive losses, right? So it's a way of risk spreading so that if you are properly insured, when 2 buildings burn down and you have a $20 million claim, you don't have to special assess your members $20 million, because that just would not work, right? I don't think anyone could special assess for $20 million. Very few, right? So what else? What other types of risk management tools are out there? Good judiciary committees, right? Because if you get rid of these stupid disputes, you hopefully don't get into court and litigation and jack up your D&O. Judiciary committees, use of ADR, CAI's ADR program is very good. Immunity amendments, the statutory immunity amendments. If you don't have the statutory immunity amendments in terms of bodily injury claims by homeowners, think about amending your documents to include the bodily injury immunity amendment, okay? Regular inspections. Why regular inspections? Fix and maintain things out in the field, right? What's the number one problem, especially in adult communities? Trip hazards, right? So any type of vertically displaced concrete, that's all risk management. If you have vertically displaced concrete, make sure you're fixing it. Make sure you're doing mud jacking. Make sure you're doing grinding that makes them reasonably flush so you don't have trip hazards. Because as you know, people fall down anyway. People fall down even if they haven't tripped over something on your property. But if they fall next to a trip hazard, you're certainly going to get a picture of that trip hazard in the lawsuit against the association. No question about it. Even if they never touched the vertically displaced concrete slab. All right. What about snow removal, ice removal, usage of salt? You know, this past week we saw these little glazes of ice, and we got phone calls that we don't like getting that say, well, Fran, this is the thing. Yes, there's a sheen of ice in Middlesex County. We think it'll melt by, say, 1:30. Our governing documents only say that we have to do snow removal activity after 2 inches of snow accumulation. Can't we just ignore it and hope it goes away? It really depends how much you want to pay for the broken hip, right? Because the broken hip's coming. We all know that the broken hip's coming. So you have to take reasonable steps, notwithstanding these provisions. And I think there's a really good argument for taking that 2-inch provision out of governing documents. I know Hovnanian back in the day used to put that 2-inch obligation in the governing documents. There's probably a decent argument for taking that out of there, because it leads associations boards, especially those who don't participate on these calls, to say, hey, it ain't 2 inches, so we don't have to clear the snow. Don't worry about it. That's bad risk management, right? Even though I know it costs a tremendous amount of money to spread salt, to spread calcium chloride, and or to send the plows out, right? And then because what happens is, I know the board members, I know many of the board members on this call, the board members get the phone call that says, why is the guy running around spreading salt everywhere? Everything looks dry. You're wasting our money. Why are you wasting our money? You hate us, don't you? Right? No, we don't hate you. We just don't want you to break your hip. Okay. And more importantly, we want to make sure everyone is safe and no one gets hurt anywhere in the common property. Even if you don't break your hip, God forbid you break your head, right? You don't want to do that. And you also don't want the association tagged for 500 grand in liability, right? So, because talk about impacting your loss run, that's a bad thing. Another thing that you can do, and I've had this at some of the associations we represent, where you start doing things if your association is aging in place, right? And you have to be careful with this, and you have to talk to engineers and architects. But if you have a population that's aging in place, and especially in an age-restricted community where everyone moved in 30 years ago at 55, and now the average age is 75, 80, people aren't necessarily disabled, right? You've heard me say this before, but they're often less abled, right? Less abled. So even if arguably you're not obligated to do something, you may want to do it anyway, because it may be a good thing and make your homeowners happy. And it also may protect you against risk. A good example that I had in my career was, we had an age-restricted community, and there were 2 people in the entire community who wanted automatic opening doors put on the clubhouse, because they were older people. They weren't as strong as they used to be, and they had a very hard time opening the non-automatic doors. And it was an expensive retrofit to put in automatic doors in the clubhouse entryway, and many people didn't want to do it. Ultimately, the board said, hey, we don't want somebody falling down. We don't want the wind catching the door, et cetera, et cetera. We're going to do it. So the good news there was nobody fell down, struggling to get the door open, caught by the wind, et cetera. And massively, the members of the community were really, really happy once they had the automatic door installed. So it was a good risk management tool, but it was a good thing in terms of lifestyle for the people who are living in the community. So that's a good thing. What about personal insurance? So personal insurance is the homeowner's insurance. So you have generally, and there's lots of them, but HO6 and HO3 policies, right? So HO6 are generally for the condo associations. HO3 are generally the homeowners association. And we'll talk a lot about that later on. Let's see how we're doing for time. The commercial insurance is the association's insurance. So what do you generally have? You have property insurance. If the building burns down, what happens? Who pays for it? You have liability insurance. What happens if the property manager hits somebody in the parking lot, right? Is there insurance for that? Is there liability if somebody sues based on that? What if we don't clear the snow and ice, and mom sues us for her broken hip? Is there insurance for that? Nobody wants to be self-insured, right? Al D'Amato.
Yep.
Al D'Amato mentions there's HO4 for renter's insurance, which is true, and it's a good thing to require. Liability insurance, other types of insurance, right? So you got workers' comp, right? You got building and machinery insurance. You have employees' dishonesty insurance. You have fidelity insurance. You have D&O insurance, directors and officers. Cybercrime insurance, social engineering insurance, right? So all those different types of insurance. And when I sit down with my insurance broker every year, I ask him or her, hey, there's all these types of insurances. What am I not covered for? Tell me, and I'll decide whether or not I should sign up for that type of coverage because it's all money, right? And it's all a lot of money. But what you don't want to have happen is somebody rips off your association, um, and they characterize the claim as cybercrime, or they characterize the crime as social engineering crime, and you're thinking, I'm covered, it's a cybercrime. Depending on the policy, the way the policy is written, you may not be covered. So you actually want to sit down with your insurance representatives and talk through them as to what the various coverages are. As we talk about all the time, when you are put on notice of a potential claim, you have to, on a timely basis, put the carrier on notice. If you don't put the carrier on notice, they can deny, even if it will be an otherwise covered loss based on the failure to timely provide notice. That is a huge issue right now with insurance. And I know for you managers out there, I see a bunch of managers. A lot of times you get pushback from the board. The manager says, hey, you know what? I got an email today that says I'm going to sue. I'm going to sue the association, blah, blah, blah. And the manager goes back to the board, and the board says, hey, listen, we don't really want to tell the carrier. It's going to impact perhaps our loss run. What should we do? Let's just cross our fingers and hope nothing happens, that he's just blustering. What will happen is if you don't put the carrier on timely notice, it will be denied. One of the things to keep in mind also is, and this is the balance, not only do carriers look at your loss run in terms of losses, like, so they'll say, oh, Fran, it was a small loss. What's the big deal? It hit the carrier. Um, they look at frequency of claims, right? Because even if you don't have a huge claim, you'll say, why am I getting dinged with this um, claims run when the claims themselves are relatively small? The way carriers look at that is they say, well, wait a second. They had 20 small claims in a year. We know the big one's coming. We know the big one's coming. We know how they run their community. We know the big one's coming. So frequency of claims is also considered in underwriting, not just the size and the magnitude of claims. So you got to be very, very careful about that. And you have to decide uh, what to do in terms of what claims to submit, what not to submit. You also have to think about that in terms of what is your deductible going to be, right? Talk to your brokers about, hey, if it's a teeny tiny claim and you don't see any exposure, does it make sense, right? Does it make sense? The tough call there is a lot of times people are like, I don't think there's any exposure. And then it turns into a $300,000 claim, right? One thing to think about a lot, and this is very frustrating to boards and managers, is I think a lot of boards feel as though the renewal of the association's insurance policy is not put on their radar until the 11th hour, right? And then the board is like, I feel compelled to get backed into this thing and I can't talk to my broker. We're kind of stuck with it now. So what you should probably do, and brokers are happy to come out 90 days ahead of time and say, hey, this is where we're going. This is what we're thinking about in the year. This is how we think we can help you. This is where we think you can improve your own position. These are the risks. So some associations have insurance where they'll provide risk analysis to come out and inspect your site, and actually give you feedback on what you can do to minimize risk. So keep that in mind. I don't think anybody on this call will have something called master insurance policies. Anybody? Anybody? No. So what master insurance policies were in the bad old days, and I used to see them with some frequency, is a insurance company would have a policy naming either the property management company or a single association as the insured. And they would add, say, 10 or 15 association as so-called additional insureds, right? And then they would say, you have $2 million worth of coverage. Well, you really didn't have $2 million worth of coverage, right? Because if there was a single thing, disaster, covered disaster in a similar area and it affected multiple associations, your coverage limits would be depleted right quickly, right? So if you hear someone pitching you a master a master insurance program or a group insurance program, again, I'm not an insurance expert, so I don't want to disparage them, but question them closely and get a second opinion, because I have not had good experience with those group insurance programs. We wind up with shared limit issues. What about the actual terms of the policies themselves? And I'm not going to belabor this. We're getting a little late already, but doesn't actual cash value sound great? Actual cash value. It sounds great. You don't want that kind of coverage, right? You don't want that kind of coverage because there'll be things like depreciation, your actual cash value today. You won't have things like, does it come up to current code? So generally speaking, you want to talk to your brokers about things like guaranteed replacement costs, right? Guaranteed replacement costs. You want to make sure that you have proper coverage and that you have an appraisal, especially with your property insurance, to know that you are going to be paying the right amount of premium, right? Because not all, but some association insurance policies have what's called a co-insurance penalty. The co-insurance penalty is to make sure that associations don't underinsure to keep insurance premiums down and then raise a major claim, because what will happen is they'll apply a co-insurance penalty and the association's recovery on the insurance claim will be cut significantly. So always ask, is there a co-insurance penalty in the policy? You do not want an insurance policy with a co-insurance penalty. It's awful, right? So talk to your insurance people about co-insurance penalty, make sure nothing's in there. And also talk to your brokers about whether or not you should have a valuation of the covered property, right? Because that can help in determining how much insurance you should have. Waiver of subrogation, this is a really annoying thing. Waiver of subrogation, many board members don't like this, but what this happens in cases where there's a problem in association unit, the association's carrier pays because the association's insurance is primary. And the board says, well, Fran, can't we go back against the homeowner who overflowed the tub or left the gas range on? Waiver of subrogations means you cannot. Waiver of subrogation means you cannot. And the theoretical reason behind that is more or less the unit owner is also an insured under the association's policy. So there's kind of a theoretical argument that you'd be suing yourselves, right? You'd be suing an insured. So I think that's all I'm going to talk about today. I know that was really quick. We're going to try and look at some questions. We're a half hour in. We do have some questions. I can see again. I have my glasses back on. Chat. Go ahead, Mike. You want to grab one?
Well, I just have there's really just a couple. The first one was an update on FinCEN. And as far as I know, everything's on hold unless you heard something different recently, Fran, because I know this
No, that's correct. It's on hold.
Go stop. So
yeah, it's on hold. You probably are all blocking my email address because I sent so many emails out on FinCEN. You're like, Fran, you're the most annoying lawyer on the planet. But it wasn't my fault. It's the United States Supreme Court and all these other courts keep going back and forth. So I would not be shocked if ultimately they reinstate it and make us do it. Al says the HO4 for renters insurance. So HO4s for renters insurance is good, and we recommend it if you have tenants. Go ahead, Mike.
Have you dealt with this before? Vacancy insurance for snowbirds? I have not seen that.
I have not. That's interesting, Janet. I think we'll look at that. Is there vacancy insurance for snowbirds? I have not run into it. Not sure. Haven't heard of it. I will check it out. Wayne says, we also have volunteer accident insurance to cover our committee members. Right. So I'll get on to the second paragraph of your thing there, Wayne. So the thing to be careful about, and this is becoming a bigger issue as association members try to save money by having committees actually do things. I had an association down in Red Bank where the Buildings and Grounds Committee had gotten some chainsaws and they were trimming the trees themselves. Do not do that. We appreciate your incentive, guys. We appreciate that that you're being diligent and trying to save the association a couple bucks. But the last thing you want is a committee member to lose a few digits limbing trees. Okay, so be careful with that. It's good to have the insurance. And then Wayne says, we also have all-in insurance, which covers our unit as they were not as built, as they are not as built. So the walk-in wine cellar that I added after closing would be covered. Well, Wayne, it's nice to be you. I want to be Wayne when I grow up. I do not have a walk-in wine cellar, Wayne, but that's a beautiful thing. The thing with all-in coverage. So talk about all-in coverage. So first, the minimal coverage on property is basically bare walls insurance, right? Bare walls insurance. That's the lowest. Then you have single entity insurance, which covers up to builder's grade restoring. So if builder's grade at the original time of construction was linoleum floors and tile countertops, that's what you get. And if you had improvements like parquet floors and marble countertops, you're on your own there. So you'd have to pursue it under your HO6 or HO3 policy or out of your own pocket. What Wayne's referring to is all insurance, so that he has the wine cellar and he gets the wine cellar, he gets his quartz countertops, and he gets his fancy cabinets back. So that's a beautiful thing for Wayne. But the thing with insurance, I mean, I like the idea of all-in insurance. It's just that most associations we work with are unwilling to pay the premiums for it. Want to take the next one there, Mike?
Yeah, so the question is association insurance versus HO6 and property loss versus the deductible. So this comes up almost on a daily basis on my end, or at least certainly weekly basis. When there is a loss that exceeds the association's deductible and it emanates from a unit, like I had earlier today, it was a water heater that exploded or leaked or whatever, ruptured, caused a bunch of damage inside the unit, and the association and the manager did not want to submit the claim to the association's insurer. And the answer is that the association's insurance is typically primary, especially where you have a single entity type insurance policy in a condo association. Single family homes, of course, are different. But
Okay.
if it exceeds the deductible, the association submits the claim to its carrier. And I always tell the managers, if you look at it, because on one hand, it doesn't seem fair, right? It's like, why is the association getting involved with a leak inside somebody's unit? But on the other hand, that owner paid a portion of the association's insurance premiums. They pay it every single month when they're making their monthly fee payment. So it is their insurance, just like it's everybody else's insurance in the association. Association submits the claim. The deductible, if you have an insurance deductible resolution in place, you could pass that along to the owner that caused the damage. So the 10 grand then gets assessed back to the unit owner. And any betterments and upgrades, including that $10,000 deductible, can be paid through the unit owner's insurance carrier themselves, the HO6 policy. Oftentimes they'll cover some, potentially all of that insurance deductible. But the answer is the association does have to get involved in those claims, although the boards and the managers hate to hear that and do not enjoy putting those claims through.
Okay. Let's see. I think we're on Diana Love there. If the association has a party and advertise it as a non-sanctioned party, BYOB, and guests of owners come and drink alcohol at the party, that an owner serves them, would the association be liable if the guest leaves and gets in an accident? Is there some type of insurance the association should have to cover a situation such as this? That is a really good question, Diana. And it's a lawyer answer. The answer is it depends, right? The answer is it depends, but we'll talk about it a little bit more. So you open the door for me to say, one thing all of you should think about buying is the Community Associations Institute gap reports. So if you go onto the National Community Associations Institute webpage, not CAI New Jersey, Community Association Institute National, they have all types of guide for association practitioners. They're just these little books. They're pretty cheap. I think they're like 30 bucks or something. But this is the one insurance. I've had it probably for about 20 years. But they have it on insurance. They have it on legal. They have it on management. They have it on every type of thing you might imagine. But certainly look at their online library and order one of these if you're interested. But as you were sitting here and as Mike was talking, I pulled out this one, and it says typical exclusions in an association's insurance policy, standard exclusions. Liquor liability. Liability for serving liquor is excluded if it is imposed by law, if liability is imposed by law. So dram shop acts, and I haven't done research on this recently, but my recollection is New Jersey does have dram shop acts that if you're serving, you can be liable for serving, or if the insured is in the business of selling, serving, or furnishing alcoholic beverages. So that's pretty broad, right? Selling, serving, or furnishing alcoholic beverages. So we worked with an association in Secaucus that actually had a bar it was a high rise, in their club room, a real bar with a real bartender and all the whole 9 yards. So they were for real selling. So they had to have separate policies for that. But there are associations that really push the envelope on this, and they are, paying a fee, and we're not selling you wine, but you paid us $45 and we put out cases of wine and you drank it, right? What's happening is if someone gets hurt, either falling down the front step because he's hammered out of his mind and he walks out the clubhouse, or he, God forbid, drives away in his car and hurts himself or somebody else, you're going to have a claim. The question is, though, and it's a much more detailed discussion with your carrier. The general commercial general liability policies generally do have coverage um, for host liquor liability. The question is, Fran, when does it go? When does it cross the line from host liquor liability? You know, uh, Madeline invited me over to check out her Eagles jacket. She said, Fran, the Super Bowl's on Sunday. Come by the clubhouse. And Madeline brings a bottle of wine with her, and we split the bottle of wine. Okay, is the association going to be liable for that, or is it going to be covered under the policy, even if I do sue later? Probably would be coverage, right? Probably would be coverage. It wouldn't say the association was serving, wouldn't say the association was selling, but it's very fact sensitive. So if I got drunk, God forbid, drove home after the Eagles won, I was partying so much, and I ran my car into a telephone pole, the my claim would probably be covered by the association's carrier if I did sue. But where you get into the gray area is you're going to wind up with, is it excluded or is it not? So anyone who's involved in liquor on premises at all should be having a conversation with their broker and the carrier reps right now to make sure they have proper coverage, whether it's host liquor liability, or there are things, or at least there have been, I haven't run into it recently, where you can buy 1 day policies and even 1 day liquor licenses, right? To have parties, to have insurance. So you can do that. A lot of people don't do it just because of the expense, but it's well worth the expense. My footnote besides the gap reports, which are wonderful, my footnote on alcohol, and I am not a teetotaler. I'm not a partier. I don't really rock out anymore. Not that I ever really rocked out, but the uh, the I'm not a teetotaler either. So there's nothing wrong with having a few drinks now and then. What I have found post-COVID is, though, that, right, people are nastier post-COVID, right? And you've heard me say this several times. And it seems that post-COVID nastiness is really enhanced if you add alcohol. So we have had issues, and I'm involved in a case right now involving this, where it's not that the residents were drinking and partying and then ran their car into a tree or fell down the front steps of the clubhouse, but they started doing funky things to association staff or saying funky things to other members, and they weren't so happy drunks, right? So the problem there is I have found that some of the alcohol consumption by not so happy drunks has led to D&O claims, right? Not liability claims, but D&O claims. Why did you let the manager get harassed? Why didn't you stop him? He should not have been doing that. How can you speak to me that way? You tried to touch me, blah, blah, blah. All those types of claims. So you got to be really careful about that and talk to your carriers about whether those types of claims will be covered in the consumption of alcohol in the association's premises. All right, Mike, you want to take the next one?
Would bare walls insurance ever be recommended for a townhome community? I don't understand how it would work or be effective, but there's a board member that's proposing it. So, well, first of all, the insurance policies will mirror the association's governing documents. So if you are going to look at bare walls policies, you probably would first have to amend your, in this case, declaration of restrictive covenants or the bylaws in the community to permit bare walls. I truly am not familiar with many associations at all that have bare walls. I know of one high rise, I believe,
Very
has one,
rare.
but I don't know. I don't even know which underwriters would offer that. Fran, are you more familiar with it?
It's really rare, and we recommend against bare walls. The reason we recommend against bare walls is it's the missing tooth issue, right? So you have bare walls coverage. Something awful happens, and I have had this. I had a mudslide up in the Highlands. Everyone knows the Highlands by Sandy Hook. Mudslide came down the hill, knocked out 2 units, blew through the townhouses. Thank God no one was killed. If they were at home, they would have been killed. One association unit had insurance. The other association unit did not. The association had bare walls coverage. The association came in and restored to the studs, period. That's all they did, right? They restored to the studs. Everything from the drywall in was on the association's unit owner. The woman who did not have insurance also did not have enough money to rebuild her unit. So for some months, we had a missing tooth, if you will. It was a shell of a unit that she could not get up to habitability standards and didn't have the money to do it. What she ultimately had to do to save her fanny with our mortgage company is she sold it to a flipper. A contractor came in, bought it from her at a fire sale price, and he built it out and sold it. So that was a sad story, but that's why single entity is encouraged as opposed to bare walls, because truly, when you have bare wall coverage, the carrier is only going to give you what the common elements are, and it usually stops at the drywall. Is there a practical way to have a porter, e.g. a handy resident, to handle low-end maintenance at a lower cost than typical maintenance company without running into liability issues? If yes, how do you set it up? So, Jim, there's not a practical way to do that without liability. And there's liability in two senses. There's liability from he may be hurt somewhere, right? So there's workers' comp type issues. There's people getting hurt on the job. There's also wage and hour issues there. And I've had this case of one of our associations where they had a handyman like this, and they claimed he was an independent contractor. He was not an association employee. He had his own company, and we didn't know any of this was going on. We got the call after the state began investigating them. And so when we started asking real questions, he was working just for the association, just for association residents. There was no insurance, there was no payroll compliance, there was no workers' comp compliance, nothing. And the association decided, since the facts were so bad, that they didn't want to even had to pay us to defend the claim against wage and hour. They just paid the claim to wage and hour, and because they recognized that he was essentially under the law an association employee. So it's two issues: one, the insurance issue, and two, the wage and hour, the employment compliance. This gentleman was only working for the association, even though he was claiming he was a vendor that served other clients. And there's a whole list of factors of what determines whether you're an employee of an association and whether you're an independent contractor. So you have to be careful if you're calling somebody independent contractor and they're actually not. Go ahead, Mike.
The Aldamato has a couple good points. Check to see if your policy has coverage for the association's deductible. So that's on an HO6 or an HO3 policy. You can have a rider on your policy, or the policy itself can just ensure that you are covered for the deductible. And Al just points out you can get catastrophic coverage for additional living expenses. So something to look into.
That's right.
The next question here is a good question from Jim. It says, how best to handle units that are vacant, where the unit owner passed away and ownership is maybe tied up in court, or there's an estate or it's abandoned. And there's, the concern about freezing pipes. So generally speaking, governing documents will provide authority for the association to gain access into a unit to ensure that it is properly winterized. If you know of vacant units, again, this pertains to townhomes or single or condo associations. You want to go inside, you want to provide the owner with notice, and then gain access with a locksmith if you need to ensure that the pipes are not going to burst. It's a nightmare. It's expensive. It causes your insurance premiums to go up. So it's well worth the money. Generally speaking, can charge back the owner the cost incurred, including gaining access into the unit, and then the cost to winterize the pipes. So definitely suggest doing that. And by the way, the New Jersey Condo Act provides explicit authority if it's a condo association for the association to do that as well.
Yep. So that's good. We do that all the time, Jim. Just so you know, we have lots and lots of cases like that. You know, sometimes people are rude enough to die on us without telling us. So annoying, right? It's really annoying. But the other thing is too, some municipalities are very, very aggressive in pursuing what they determine under the statute is, and the municipal ordinance, are abandoned units that are not being cared for. So Brick Township, for example, is pretty aggressive in pursuing vacant units and seeking to have them knocked down. So we're in a case right now where Brick Township has sent out a notice that unless the vacant unit is cleaned up, Brick is going to statutorily come in and demo it. So you hate to see it go that far, but right now that's what's going to happen. You know, unless we work something out. Mary Ellen had asked before, she must have joined us late, whether these seminars or webinars are available online. And yes, they're on at theassociationlawyers.com. She can go to theassociationlawyers.com, just search Fran McGovern. It'll get you to our website, and you upper right-hand corner is the gold button that says First Friday with Fran. Let's see, Diana, Ed, damage caused by person who compressed hot water heater breaks on its own. Oh, Ed is saying, what's the, I think there's a little typo there. What is the difference between damage caused by negligence versus hot water breaks on its own? So that's a good question, Ed. And really the courts don't, the courts don't handle this very well, I don't think. There's a New Jersey decision, a trial level decision out of Middlesex County. And he was a good judge when he was sitting. He's retired now, but he rendered a decision that said the association, he struck down an association's water heater resolution, saying it was beyond the board's power. The problem with that is we all know that if a water heater breaks in stacked units, and especially if somebody is away in Florida for a month, the water is going to continue to run. Water is going to continue to run until someone discovers it's coming through their ceiling, right? And you don't want that. So I'm still in favor of, talk to your lawyer. If it's us, talk to us. If it's somebody else, talk to your lawyer about implementing a water heater replacement resolution or a governing document amendment that requires water heater replacement. That's a really good method of trying to manage risk, and the risk can be very substantial. The difference between negligence and what would be called strict liability is hard to say in those circumstances, right? Because when should a person be aware under reasonable care circumstances that it's time to replace your hot water heater, right? Is that 15 years, 10, 8, 7? It's hard to say. But I think there comes a time where there is a reasonable standard to inspect and or replace your hot water heater, and we are generally in favor of those types of resolutions for risk management, especially in high rises. Water losses in high rises just destroy associations' financials and loss runs on the insurance policies. So, do you have another one, Mike?
I don't see any more.
All right, that looks like it. I hope that was okay. We're going to probably talk about some more insurance topics next week. And like I said in the title, remember the Alamo. San Antonio is a really cool place. That's the first time I've ever been there. If you've never been there, it's definitely worth a visit. Really worth a visit. The Riverwalk is super cool with some really nice restaurants, and the weather was very nice. It was almost like San Francisco last week out there. So nice and cool, not too hot, not too cold. It's definitely worth a visit. But thanks so much for attending. It's really great to see everyone, and we'll see you next month.